each political party had the primary evidence at the level of the polling unit of those results. So I find it difficult to understand why almost all the political parties are relying only on results uploaded to the various polling units.
This is pure deception. It's a pity that the INEC Commissioner, Festus Okoye, is trying to deceive Nigerians. IREV copies of results, they are the primary source for collation. That's what the electoral law says. Before the collation officer at the ward level can collect any result, he must make reference to the one uploaded to the IREV. All the results he collected from all the polling unit agents in his ward, before he can write anything in the Form EC8B, he must make reference to the one on IREV. It is the primary source for collation according to the law. So this man should not be deceiving Nigerians that they shouldn't rely on IREV copies. Why? Is it because they prevented the upload of results on IREV? They want to justify the fact that they prevented it, that the collation officers can depend on other copies. This is wrong. That's not the position of the law. If this is how they plan to open their defense on Monday at the Presidential Election Petition Tribunal, then they have failed. Party agent copies are even third on the ladder when you consider the probate value of result sheets. Let's debunk the position of INEC Commissioner Festus Okoye. Let's start from the Supreme Court judgment on the Osun State governorship election, Oyetola versus Adeleke. Bear in mind that this is the first Supreme Court judgment that is based on the new electoral law, on beavers and all other changes. No other Supreme Court judgments have been done on this new electoral law. So the Supreme Court judgment is the standard that the present Presidential Election Petition Tribunal judges will follow when they decide. In that Supreme Court judgment, they cited the regulations of INEC, that's their guidelines. It reads, regulations provide for the beavers to be used to scan the completed result in Form EC8A and transmit or upload the scanned copy of the polling unit result to the collation system and INEC result viewing portal, IREV. Regulation 38 of the regulation reads thusly, on completion of all the polling unit voting and results procedures, the presiding officer shall electronically transmit or transfer the results of the polling unit direct to the collation system as prescribed by the Commission. Number 2 says, use the beavers to upload a scanned copy of the EC8A to the INEC result viewing portal, IREV, as prescribed by the Commission. Number 3, take the beavers and the original copy of each of the forms in tamper-evident envelope to the registration area / ward collation officer in the company of security agents. The polling agents may accompany the presiding officer to the registration area / ward collation center. So the Supreme Court upheld the INEC guidelines that it is the procedure for the polling officer to follow. The most important takeaway is that the Supreme Court said that the primary source of results during collation is the one uploaded on IREV. This is the major reason the electoral law was amended. So why are these people avoiding obeying the same law that they are supposed to obey? The only way to protect what the people voted for is to upload it on IREV. So why didn't they upload it on IREV to protect the will of the people? Now he's just giving excuses and saying he doesn't understand why people are relying on IREV copies when they have political party copies. Is that the position of the law? That's not the position of the law.
After the election, we are going to transmit the election, collect the election at the collation center, and so we are not transmitting it here at the polling unit today. Why?
Now let's look at the section in INEC's own regulations and guidelines for the conduct of the election. An election result shall only be collated if the collation officer ascertains that the number of accredited voters agrees with the number recorded in the beavers and votes scored by political parties on the result sheet is correct and agrees with the result electronically transmitted or transferred directly from the polling unit as prescribed in these regulations and guidelines. So you can see their own guidelines. It says it shall only be done, collation shall only be done if he's able to compare the results with the electronically transmitted one, which is the one on IREV. If a collation officer doesn't follow this procedure, he's doing nothing. He's invalid in the eyes of the law. They didn't follow procedure. B says, if a collation or returning officer determines that a result from a lower level of collation is not correct, he or she shall use the result electronically transmitted or transferred directly from that lower level to collect and announce the result. So you can see it continues not just at the ward level, even at local government level or state level. If they detect any problem, they still have to make reference. The Electoral Act does not say that INEC must upload from EC8B at the ward level or at local government level and other levels. It doesn't specifically say that. But they can do that if they are interested in transparency. They can do that to improve the trust that people have in election. Because if you finish collating at the local government level, you can just say, okay, let's snap it and upload, so that at the state level, they will say, yes, this is the correct result. It was uploaded. This is very important because it is even covered in their guidelines. Let's take a look. It says, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IREV portal to continue collation. Where none of these exist, the collation officer shall ask for duplicate hard copies issued by the Commission to the following bodies in the order below: the Nigeria Police Force and agents of political parties. So you can see the order. This is the same way the law sees it. That's the probate value. But the primary one is the INEC CTCs. They are not supposed to be a party when they are conducting an election. They are supposed to be neutral. But they are not neutral because they have not tendered all the CTCs required by the petitioners. Up to today, CTCs from Obiakpo local government in Rivers State have not been tendered by INEC. Why? If they are not biased, if they are truly sure of the election that they conducted, why are they withholding some of the documents? Why were they avoiding subpoena? They say guilty conscience fears no accusation. If they know truly that they didn't do anything wrong or that what they did was correct, why did they fail in submitting all the documents, in giving the petitioners all the documents that they require, even before the sitting of the tribunal started? Some people are complaining about the small number of witnesses that Labour Party called at the tribunal. The Labour Party initially said that they will call 50 witnesses but ended up calling far less. How will that affect their case? Well, let's look at Section 137 of the Electoral Act, because all what we have said borders on the fact that INEC did not comply with the electoral law. So this section deals with non-compliance. It says, it shall not be necessary for a party who alleges non-compliance with the provisions of this act for the conduct of elections to call oral evidence if originals or certified true copies manifestly disclose the non-compliance alleged. So as you can see, this section covers that. You do not need to bring thousands of witnesses to prove your case. In fact, there's no time for that. It is not about quantity. What matters is the quality. The problem is that when you look at the electoral law, it puts a lot of burden, the burden of trust on INEC. When you look at many sections, they are expecting that INEC will do the right thing. When you look at the laws and guidelines, it is expected that polling officers must upload forms EC8A after vote counting at the polling unit. This should be done in front of everyone, so issues like wrong uploads should never arise. But we all know what happened. The results were never uploaded at the polling unit. So it's obvious that INEC didn't follow the guidelines and the electoral law. In this case, it leads to a question whether the non-compliance of the electoral law by INEC affected the outcome of the presidential election in a huge way. There's a section that covers that in the Electoral Act. Let's take a look. An election shall not be liable to be invalidated by reason of non-compliance with the provisions of this act if it appears to the election tribunal or court that the election was conducted substantially in accordance with the principles of this act, and that the non-compliance did not affect substantially the result of the election. The main word here is substantially. If the tribunal judges think that the non-upload of forms EC8A at the polling units during the presidential election substantially affected the outcome, then they might cancel the election. But their description of substantially might be different. And going by the Supreme Court judgment on Oyotola versus Adeleke governorship election dispute, that the primary source of results during collation is the one uploaded on IREV. The question now is, did the collation officers use the police copies or political party agent copies to cross-check and collate the results during collation? So it all depends on how the judges see it. But cancellation will be a very expensive adventure for Nigeria now, because it will take out billions of naira to conduct a fresh election. They should just focus on the certified true copies and the other documents that the petitioners tendered so as to determine a true winner of the election so that Nigerians can have closure. Thanks for watching.